As to problem number 23, the plaintiff was witnessing a cricket match at a stadium organized by the Cricket Club of India. He was seriously injured by a mighty hit from the batsman. Consider the liability of the Cricket Club of India and the liability of the batsman. In this problem, we found a similar fact that was decided by the King's Bench, and the very leading case is that Murray versus Herringway Arena Limited, and the year was 1951, and it was decided by the King's Bench. A boy 6 years of age was taken by his father to see an ice hockey match in the defendant's arena. Shortly after the match had begun, the puck, a rubber disc 3 inches in diameter and 1 inch thick, with which the game was played, was knocked out of the ice ring and struck the boy over the left eye, causing injury which seriously impaired the sight of the eye. In an action brought on behalf of the boy for damages, it was held that there was no implied obligation on the defendants under the contract between the parties to protect the spectator against such damages as might be incidental to the game, which any reasonable spectator could reasonably foresee, and of which he took the risk. Therefore, in our problem also, the batsman and the Cricket Club of India are not liable. And now we'll go to the problem number 24. The plaintiff's minor daughter was acting as a housekeeper to X while she was on service. She had no intention to her father, and she was seduced by the defendant. After seduction, she went to her father's home and was maintained by her father. Can the father sue for seduction? So, in the facts of this problem resembles the facts of the case of Din versus Pill of the year 1804. In this case, the facts were the daughter, though underage, was acting as housekeeper to another person at the time of seduction, and had no intention to return to her father's house, though afterwards she did return. While within the age, in consequence of seduction, and was maintained by her father, it was held that no action lies. Thus, on this problem also the father can sue for citizen. And our next problem is problem number 25. The defendant the defendant sent for sale to a public market pigs which were to his knowledge infected with a contagious disease. They were put up for sale subject to a condition that no warranty would be given and no compensation would be made in respect of any defect. The plaintiff bought the pigs and put them with other pigs which became infected and some of them died. The plaintiff sued to recover damages. Can he succeed? The facts of this problem similar to the facts of the case, and that was Ward versus Hobbs in the year 1877 decided by the Queen's Bench. In this case, the facts were the defendant sent for sale of pigs to a public market which were to his knowledge infected with contagious disease. They have exposed for sale subject to a condition that no warranty would be given and no compensation would be made in respect of any defect. The plaintiff bought the pigs and put them with other pigs. Some of the pigs died of the disease. This sued to recover damages for loss he had sustained. It was held no action lay for the defendant's conduct in exposing the pigs for sale in the market did not amount to misrepresentation that they were free from disease. Thus, in the problem, the plaintiff cannot succeed to recover damages. And now we'll go to the 26th problem, and that is the plaintiff purchased a ticket for a seat at a cinema show, but the manager was under the mistaken belief that he had not paid for it. The manager directed that he be turned out of his seat. Accordingly, the plaintiff was forcibly torn out of the seat. He filed a suit to recover damages. Can he succeed? The facts of the case was similar to the facts of the case that was Horst versus Picture Theatres Limited in the year 1915. It was decided by the King's Bench. The facts of the case were the plaintiff who had purchased a ticket for a seat at the cinema show was forcibly turned out of his seat by direction of the manager who was acting under a mistaken belief that the plaintiff had not paid for his seat. It was held that the plaintiff was entitled to recover substantial damages. The purchaser of a ticket for a seat at a theatre or other similar entertainment of the performance, provided that he behaves properly and complies with the rules of the management. Thus, in this problem, the plaintiff can succeed to recover damages.